This is Legal Live with Farah and Farah, talking about the latest legal news and answering your questions. To call Legal Live and ask your question, dial 855-765-1045. That's 855-765-1045.
Happy Saturday to you. My name's Justin. It is Legal Live, sponsored by Farah and Farah on 104.5 WOKV, Jacksonville's News and Talk. Phone lines are open, 855-765-1045. That's 855-765-1045. If you'd like to call in with your legal questions.
That's right. That's why we're here.
Yeah, of course. And I remember, we had some great calls last week.
Oh, yeah. It was a great show.
Yeah.
It's always good to hear the interesting situations people are in, and we can learn from those situations.
Mm-hmm.
We all learn from it. We learn from it, and hopefully our listeners learn from it too. But we're going to talk about some things I want to talk about. But, of course, as you say, Justin, the phone calls are a priority. If you have a question or a comment about the legal system or a situation you're involved in, you want to talk about the legal system, you have any kind of question or comment, we're all ears, and we can handle it.
Yes.
We've heard it. I always say we've heard it all, but every time I come here, I hear something different.
There's something new.
Something new. But I want to talk about a situation that happened, and I've talked about this before, but we had a call this week because we do employment law also. We represent people in like overtime cases, hostile work environments, discrimination type situations. Mm-hmm. Well, here is a case, interesting, because this lady called us, and she was she worked for a church, and then something happened, and she got fired, and and she called us about it. But there's a Supreme Court decision that deals with employees that are working for a church or a religious organization, and this is a Supreme Court decision, a U.S. Supreme Court decision that was decided about 13 years ago. And it was a unanimous decision among the U.S. Supreme Court. And basically what it says is that if you are claiming some sort of employment discrimination or employment issue, that you really can't do it. You really don't have a claim because if you're involved in the church, because the church is a First Amendment, it's a freedom of religion. In this particular case, the Supreme Court, which is not too different than what we were dealing with at our office, was a lady who was working for the church. She went out on disability. She had some sort of medical condition. When she came back from her disability, she wanted her job back. Under FMLA, they got to keep it open for a certain period of time. You may not get paid during the time you're on FMLA, but your employer is required to keep your job open for a certain period of time. Well, she comes back to work, and they say, we filled it. You don't have a job anymore. And so she goes to the EEOC because typically on these employment claims, disability, discrimination, stuff, things like that, you have to go through an EEOC sort of vetting process. And the EEOC will then issue an opinion whether you have a right to sue or not. In this particular case, they gave her a right to sue. So she tried to sue the church for, getting rid of, not bringing her back to work when she came back from a disability. And it went all the way up to the U.S. Supreme Court. And the U.S. Supreme Court stated that it's a First Amendment thing. Churches have a right to run their own organization. They don't, in this particular situation, they don't have to comply with the Americans with Disability Act. You would think they would, but they're not. Even though she's getting a W-2 and she's fully employed, churches are immune from that. They don't have to comply with the Americans with Disability Act. Therefore, you don't get your job back. And the Supreme Court would, if these discrimination laws applied to all churches, then you couldn't just have male Catholic priests.
Sure.
You would have females. That's discrimination, right? You only have men or Catholic priests, no women. So, and the court went on and on about that, and it was interesting because it went back. The court referred that this has been kind of the situation since the Magna Carta, which was 1,500 years, 1,200 years ago. That even back then in Old England, when the Magna Carta was drafted, the churches really have their own governing. They govern themselves, and so that was an interesting situation. And So it was. So they said based on the Magna Carta, First Amendment, we can't tell churches how to run their business. It's a religious thing, and we're going to stay out of it. So if you do work for a church and you're involved in and this particular person in this case she didn't just work for the church. I mean, she wasn't like just an accountant. I think she was actually involved in having services and leading people in prayer. And even though she was like a clerical person, she was doing like secretarial type work. She was also involved in, functions of the church, religious functions. And that tied her into the church. I don't know if that would be the same case if let's say you were just a bookkeeper.
Right.
And you had nothing to do with the religious stuff. Then you would probably do something, but generally can't do it.
Is it kind of similar to what we were talking about a few weeks ago with the Indian tribes and like Hard Rock, how they're their own governed entity kind of?
Right. The tribe, Chief Osceola at the Hard Rock is they're sort of an independent entity from the U.S. government. Mm-hmm. And it's very difficult to sue them when you're, God forbid, you're hurt. Mm-hmm. If you lose money, you lose money. You can't sue them for that.
Right.
Well, we're going to talk about that in a minute. There is a class action on people who are addicted to gambling, but we're going to get into that later. But generally, if you're hurt on Indian property, you have to get their permission to sue, and that's very difficult.
Would that be a similar situation for like employment? Like you work for them, you go away and come back? You
know what? That's a good question. They probably, since they have their own entity, they probably also have their own laws dealing with discrimination and getting your job back. That's a great question. I'll have to find that out.
We'll have to check it out.
I'll report back, Justin. You're thinking like a lawyer right now.
It feels similar. That's why I was asking.
You're in the wrong line of work right now, Justin. You got to make a change, a lifestyle change.
Well, that sounds like a lot of schooling. I don't know if I could. We got Riley on the line, but we're up against a break, so let's go to break so we can.
We'll take her. We got an answer for your question.
Yeah, Riley, we'll get you after the break here. Obviously, if you've got a call as well, 855-765-1045 to call in to Legal Live, sponsored by Farah and Farah 1045 WOKV. Jacksonville's News and Talk. We'll be right back. This is Legal Live on 1045 WOKV, Jacksonville's News and Talk, sponsored by Farah and Farah. 855-765-1045 is the phone number to use to call in if you've got a question for the show. And that's what we'll do. We'll pop right out to the lines. We'll go over to Riley, who is calling in. Looks like we're talking about power of attorney. Riley, thanks for calling in to Legal Live. What's your question?
Hi, good afternoon. First off, love the show. It's my Saturday afternoon go-to.
Thanks a lot, Riley.
Currently, I am experiencing an issue with a sister who's been picked up and remanded to a rehabilitation center in a different city than Jacksonville right now. And as we dig further and further into her situation, I'm getting stonewalled by everybody because I need a power of attorney to handle some of her legal, financial affairs and some of her medical situations that's going on. So is a power of attorney, is that something, one of those forms I can print off the internet? I understand they need to be witnessed and notarized and signed by her and myself,
right?
So I can take over some of her decision making.
Okay. Well, first of all,
something that's binding in court.
Yeah, it is. But
how does that work?
Okay. Well, first of all, you got to start with her. Is she mentally capable, and to understand that she's given you a power of attorney? Because if she's not competent, then it's not worth the paper it's written on.
And how would that be determined? The facility that she's in told me they rated her at a 4 or a 3 on a scale of 10. That they would not help with getting it notarized. But if I wanted notified, but if I brought in my own notary and a form, that they could not stop me. But again, would it be a legally binding document?
You know what?
Under that situation.
You mean if you had to go to the bank to get some stuff transferred and so forth? Is that what you're talking about?
That's correct.
Yeah, something like that.
Yeah, bank,
yeah.
Got to get the car.
Yeah. Change titles, pay bills, get access to the bank account, and all that.
Correct.
That would probably work. Yes. But they don't want to get involved because the reason they don't want to get involved, they don't want to be caught up in something if she comes back later and says, I was not competent to do this. And, this person took all my money. You see what I'm saying? That can happen.
Right.
Because you have full access to everything she has. If you've got the power of attorney, then you are her. You can do whatever she could do. And they don't want to get involved in that because if something goes bad, they don't want to be tied in it. They don't want to be part of that litigation.
All right. That's understandable.
Now, remember the power of attorney ceases to exist after her death.
The power of attorney.
Huh?
Yeah. Yeah, right now, I asked her if she signed a power of attorney or any other kind of documents while she's in this facility. It took me almost 3 months just to find her. So I don't know what went on prior to that. She's got a neighbor who's been involved somewhat with using her debit card to pay some bills, and now I've just recently been able to get copies of her bank statement from the facility. I'm seeing some rather strange transactions. So if there is a
what you could do
out there, if I get a new one, does that supersede anything?
You know what you could do if you really want to do it where it's super clean and you got a court order that you don't have to worry about, that you can take that court order to the bank, to the hospital, anywhere. You can go in front of a judge, have her declared incompetent, have you appointed as the guardian. The judge will give you a court. That's going to cost a little bit of money, but you can get it back from her funds. I mean, you can ask the judge to reimburse you for that money and just hire a lawyer to have you appointed as her guardian. And to explain to the judge, you say there may be something going on with some of these accounts. She's given the debit card info to some neighbors. And so you're stepping in to solve the problem. That would be the best way to do it. Okay.
All right. Would that require? I mean, is that something a general lawyer would handle,
typically,
or is that somebody that specializes in family law?
No, like a probate lawyer would do it. Some general practice lawyers could do it, but that way you're appointed her guardian. You have a court order, and that way you're immune from anything. If somebody tries to accuse you of doing something.
All right. Would it require a legal team in the same city she's in, or could anybody in the state of Florida handle that?
Well, if she's in a different city, you would probably have to have it done there, because what they're going to do when you file that petition to have her appoint as a guardian, they're going to send somebody out to interview her, and that person will report back to the judge. That's the really right way to do it. But if you want to get just a regular power of attorney, some people, I can't guarantee you they would accept it. If you went to the bank with it, they should. And a lot of people would accept it. But if you have a court order, they have to go along with it. Like she had a safety deposit. Right. So with that court order, you can walk in. I want to know all her accounts. I want to know where her investments are. I want to know if she has a safety deposit box. And they'd have to turn that over to you. They may not want to do it with just a general power of attorney. It may cost a couple of grand, but again, you can ask the court to reimburse you from her assets.
All right. Fantastic.
And you don't have to be there. You could call a lawyer in that town. I mean, if she's in Florida, you could call a lawyer in that town to do it.
All right. I think that's what I'll do next. And very good.
Yes.
Eddie, thank you for your information
and
help. And I know I made the right call today. Thank you.
Thank you very much. Yeah. See, the thing is, when you have the court order, that's what gives you nobody can say, well, we don't like, you can go to some places. I've seen it before. We don't accept this power of attorney.
Really? Like a bank?
Yeah, they don't have to take it.
Yeah, they don't like
it's just a notarized document. But if it's a court order, and he'll get a seal on it from the judge, signed by the judge.
Yeah.
And I
bet that situation, too, has got to be tough where, like, maybe you don't know even how to start that, and it's already a stressful situation to begin with. Yeah. Like, that's got to be really, I guess the word's upsetting. But
yeah, and, well, he suspects that somebody's doing some...
And now you think that, too. So.
Yeah, so, and that way he's protected, the court would... So that would be the right way to do it.
So in theory, if he were just to go get the normal, like what he was talking about, just get the power there, and then the neighbor thinks he's doing something funky, he could still be
or
at risk.
The neighbor could state that this person was not even competent to do the
and then that
to
could get a legal
sign
battle
over.
going.
And what is he doing? Taking her money and doing this and I mean he then it just gets so
Now
gets
you're in a
involved.
whirlwind. Yeah.
You're dealing with all these suits and these claims, and Riley doesn't need that.
Yeah.
Gets a court order from the judge. He's in charge. He can cut that person off from the debit card.
Yeah.
First thing he would do is cut them off. Goes to the bank and cuts that person off. And he has the right, if he thinks there's something going on with the account, there's some monkey business going on, he has the authority to file a suit against that neighbor who may have been taking money.
On her behalf.
Yes.
Yeah.
Right. So that's the way to do it.
Okay. That's good to know. Yeah, power attorney sounds like a stressful situation in general, but that's good information. So.
Yeah. Okay, well, let me see. I'll move on to, I want to talk about something else here. I got it.
Okay.
But before we get another phone call.
Yeah, while we're waiting, the phone, if you would like to call in, 855-765-1045. Phone lines are open, 855-765-1045 if you'd like to call into Legal Live on 104.5 WOKV.
Yeah, okay. I'm going to get into, we talked about a couple of weeks ago, we've been talking about that lawsuit that had to deal with, Facebook and Instagram Meta, where these people were able to sue because they were addicted. These are children. If you want to make a claim, if you know someone, the parameters are you had to be under 18 when all this started, and you had to have so many hours of usage a day, and they can track that. And you have to have some sort of mental condition. A lot of these people have body dysmorphia. They have have anxiety, whatever it is. So you have to have some sort of medical condition. But if you do, you do have a claim. And I think if you are not over 25 years of age, because there's a statute of limitations issue also, but if you started having the problem when you were 18, used Meta for so many hours a day, and you're having a problem, and that claim is based on the fact that what they presented to you was a defective product. They knew it was addictive. They created it to be addictive. That was the whole purpose, is to get you hooked, and so you'd stay on it. That's how they make their money. So it was a profit-driven thing. When they knew that people would be addicted to it, they even had evidence that people were having problems after they were addicted to social media, yet they continued to serve people whatever they're looking at, hook them in. So that's the basis of the lawsuit. And the first trial resulted in a $6 million verdict. You're going to see many more lawsuits on that. There are thousands of them now that are filed throughout the country. But it's based on an addiction. Just like cigarettes were addictive, that's what those lawsuits were based on. Well, there's another case going on, and this is a class action it's in Alabama, Mississippi, Arkansas, Ohio, Georgia, and Oregon. And it's based on illegal online gambling. There are people who are hooked on illegal online gambling. And this class action is representing these gamblers because there are laws on the books right now that allow you, if you're a victim of illegal gambling, then you have a right to sue to get all your money back.
Go after the bookie.
I love it.
Yeah.
You got to go after them.
Yeah.
So now we talked about the Magna Carta, but this law originally was on the books it's called what was it called? The Statutes of Anne back in 1710.
Wow.
And the English people knew, the government understood that gambling could tear a household apart, that people would just squander away everything. So they passed this law back in 1710, over 200 years ago, 300 years ago, that allowed people to sue for their gambling losses. So now this law is still on the books, and there's a class action going on, and it's based on it's a gambling loss recovery statute. If you are a victim, you got to file it within 6 months of the loss. So there is a short statute of limitations. Yeah. You've lost money. You know somebody who's lost money to illegal gambling online, and there's so much of it online now that you can file a claim for your losses. And this is unregulated gambling. It's not regulated. It's all over the
this
internet.
isn't like a FanDuel
or like
Hard Rock.
Hard Rock
Yeah.
or anything. FanDuel or Hard
This
Rock.
is a
MGM.
Yeah, those ones are the legal ones.
This is unregulated.
Yeah.
And it allows you, it's called the Gambling Loss Recovery Statute, and it's not a new law, but there's a class action going on, and there's people that hopefully will get their money back.
Who might need it. Yeah.
Yeah.
Okay. Well, let's head to break. And again, remind the phones.
I got some more gambling stuff.
Oh, good.
Gambling.
Listen, I'm all
some
about
more
it.
class actions.
Class actions? Okay.
Class actions.
855-765-1045. That's 855-765-1045. If you've got a legal question as well, we'll get you after the break here on Legal Live on 104.5 WOKV, Jacksonville's News and Talk. We'll be right back. This is Legal Live on 104.5 WOKV, Jacksonville's News and Talk, sponsored by Farah Farah. Happy Saturday to you. My name's Justin. We are answering your legal questions, 855-765-1045. That's 855-765-1045. Talking a lot of class actions.
Well, it's Addiction Saturday. We're addicted to social media. We're addicted to gambling. And now we're addicted to video games.
And the show, before us, Smart Money, they were talking about the numbers of young men that are on sports betting apps and betting. It's pretty high number.
I mean, because you can go bet $5.
Yeah.
I mean, you don't have to bet. You can be a low stakes gambler and still be part of the process and have fun.
Yeah, I mean, if I got a Phillies game on,
I'll tell you, during football season, because I got the Hard Rock app. I mean, it's Saturday night. You got those West Coast games starting on, Arizona State versus Fresno State. I mean, you're not too excited about it, but you want to watch some more football.
Gives you a little.
It doesn't
extra.
start till 11. You make a bet, you're staying up till 2 a.m. watching the game. You ain't going to sleep. You got money on it, and to me, that's what's more fun than that.
Gives it a little extra motivation for the game too.
For sure,
I get it.
Even though it's two teams you really don't follow, you're following it that night.
You're locked in.
Yeah, you're locked in. That's the beauty of it. Okay, well, we talked about this Addiction Saturday. Now we're talking about being addicted to video games, and it's called Internet Gaming Disorder. It's affecting adults between 18 and 35 years of age. And these are people that are addicted to. I know people. We all probably know people.
It might be me, honestly. I'm waiting for your description.
So anyway, what it is, internet gaming disorder happens when it's difficult to control, and it starts. You're just so addicted to these video games. It interferes with your work, school, and disrupts daily functions. That's internet gaming disorder. It also can create anxiety, depression, attention difficulties. And what these companies have done, they have built an addictive feature into these products that maximize engagement, because more engagement, more revenue. And so they want to hook you in on these video games. They do it with, reward schedules, time-limited events, virtual currencies. Those are some of their tactics. But there are now numerous lawsuits based on this internet gaming disorder. Mm-hmm. So I'm telling you, there's something for everybody.
Yeah.
We got something for everybody.
Well,
today.
You're talking
We're
about
all into addiction.
What else
can we
real.
do?
What other addictive things can we talk about? Class actions.
Man, everything is addictive. You can make that argument on any kind of product.
Well, and honestly, because I've grown up playing video games. It's changed. Back in the day, you just played, the campaign mode. Now there are weekly tasks and
and people are, it's taken over their life.
Yeah.
And they were designed to do that because, of course, it's all about the revenue.
You're trying to bring people back.
Get them back and spend their money.
Yeah.
So, anyway, okay. Enough of addiction. We talked about 3 addictions
Too much.
Okay. Let's get to talk about dog bites. Okay, let's kind of bring it back down to something.
Yeah.
Okay. Florida has a very strict dog bite statute. And it's a strict liability that you're bitten by a dog. You're responsible. Your dog bites somebody, basically
it's on you.
Yeah, it's on you. Now you can reduce some of that responsibility if he was antagonizing the dog or dealing with the dog. I mean, I mean, if he was edging the dog or doing something to aggravate the dog, you could probably argue that. But that doesn't escape liability. It may reduce some of the recovery. But generally, it's called strict liability. And provocation, if he's provoking the dog, you can maybe argue he provoked my dog, that's why the dog bit him. Still, it's strict liability. It used to be, under the law, that you had to prove that you knew or should have known your dog was vicious or that he had bit somebody before. It was called the one bite rule. Your dog got like one free bite. But that's how it's gone.
Yeah, you get
they
one
changed all that, I think, in 1993. So it went from the one bite rule. You don't have to prove. I mean, you could have the friendliest dog in the world. He bites somebody, you're responsible. You could say this dog never bit anybody. He couldn't harm a flea. No, this dog, if he bites somebody, you're on the hook for it. So there's no, you don't have to, nobody has to prove that you knew the dog or should have known the dog was vicious.
And then if that's the case, are you going after, is it like a homeowner's
Your
insurance?
homeowner's coverage, yeah. Mm-hmm. Typically covers it if they have coverage for it. A lot of insurance companies do not write homeowners coverage with dogs anymore, covering dog bites. So you got to make sure you have that on your policy if you have a dog. And some companies, even if you tell them you have a dog, based on the breed of that dog, they will not insure you. So that's another thing. But you got to, and there are companies that will. There are some companies that will not insure certain dogs. That you're gonna have to find a different insurance company if you want coverage. You know, if you don't have coverage and your dog bites and hurts somebody, then you could be personally responsible. So that's why you want to have insurance for that.
Some of those bites can do some damage. Yeah.
So Buffalo law does give you some relief. If you have a beware of dog sign, it has to be adequate. What is adequate? The law, the statute doesn't say what an adequate beware of dog sign is. The courts have said it's a jury question, which means that if you have a beware of dog sign and somebody comes in and is bitten and you say, well, Judge, I got a beware of dog sign, and according to the statute, I'm not responsible. You still have to prove the warning was the beware of dog sign was adequate. And that's a jury question. The judge doesn't decide that. That's what the jury decides. Of course, the person who's bit going to say the sign wasn't, I couldn't see it, or was on the side, or it was so small I couldn't see it. So it's a jury. It's what the jury believes is an adequate beware of dog sign. But the beware of dog sign does give you protection, and it's something you want to have in your yard if you have a dog that you feel may bite someone. My question is, if you invite someone into you got the beware of dog sign that everybody sees, but yet you invite someone in, and then the dog bites them. We'll have to see how that pans out. I don't know. I was just thinking about that this morning.
Yeah. What if it's the opposite? What if someone's, jumping your fence in the backyard?
Like a trespasser?
Yeah.
Then, yeah, you're probably out of luck. Yeah. Because you're a trespasser. You have no right to be on the property.
Right. And so that's at least the counter argument there to kind of put that to bed.
Now, there are situations where trespassers can still make a claim.
Really?
And yes, and an argument could be made that the trespasser could argue that I didn't know the dog was there. I didn't see a dog. The dog came from nowhere. I mean, if someone's trespassing on your property, you have very little duty to them. Under certain circumstances, if there are hidden dangers on your property that you know about and the person who's trespassing doesn't know about or wouldn't be able to figure out, and people are kind of trespassing, then you could be held responsible. We had a case we talked about a few years ago where this landowner had no trespassing signs on there. It was out in the country. They had these no trespassing signs all over the fence, but they knew trespassers were coming onto their property, and there was a trap on the property, and somebody was injured. And that trespasser was able to make a claim because the landowner knew that trespassers would be on their property and knew there was a hidden trap on the property. So anyway, there are no absolutes in the law typically, but trespassers don't have a lot of rights.
Yeah.
It's going to be a tough case.
That's interesting. All right.
Yeah.
Well, let's head to break.
Okay.
Open up the phone lines one more time. 855-765-1045. That's 855-765-1045. If you've got a legal question for Eddie to answer after the break on Legal Live on 104.5 WOKV, we're Jacksonville's News and Talk. We'll be right back. Legal Live on 104.5 WOKV, Jacksonville's News and Talk, sponsored by Farah Farah. Eddie here to answer your legal questions, which we'll jump right out to the lines. We got Mark on the line. Mark, thanks for calling into Legal Live. What's your question?
Hey, Mark.
Yes. So purchased a new vehicle, wrote a check for it, and 4 days later had a problem, had to have them bring out a tow truck. They kept it for 8 days and fixed it. That was with just a few miles on it. Now, fast forward about 5 weeks, had another problem, had to drop it off. And I guess my concern is when is this become a lemon?
Yeah, okay. We have an attorney in our office that handles warranty cases. I know something about the Magnuson-Moss. I can explain to you how Magnuson-Moss works. That's a federal law. The lemon law you're talking about is a state law. I like the lemon law case in Florida because if you prove it up, then they got to buy the car back, okay? Every penny of it. But the problem with the lemon law in Florida is you don't get a lawyer to handle it on a contingency. You're going to have to pay money. We only work on a contingency. So we handle Magnuson-Moss cases, but not lemon law cases. Because lemon law is going to take some litigation, and you're going to have to pay a lawyer to do that. Now, of course, we'll get your money back for you if you're successful. But right now, I don't know of any lawyers in our area that are doing lemon law. You may want to do a Google search. But if you want to do a Magnuson-Moss type case, you have a clear cut. You have to, under the Magnuson-Moss Act, for you to make a claim, you got to give them 3 repair attempts. Now, you've only had it twice, but you have to give them a 3rd repair attempt. And if they can't do it after 3 attempts, then you have a claim under federal law under the Magnuson-Moss Act. So you have two avenues to follow: either the lemon law, where they buy the car back from you, or you have the Magnuson-Moss Act, where they'll just pay you some money. I mean, you may get them to. That's between the lawyer and them, how much you get. Does that help at all? Or?
I don't know if I confuse you. It's 2 different issues. Mm-hmm. So it's not like they're working on the same issue the second time.
Right.
So it just,
but I think even after 2 under lemon law, I can look it up and the statute. Have you looked up the statute? It tells you what you got to prove. I don't think 2 repair attempts are enough. We're trying to look it up if we have time. I know we only have a couple of minutes yet. Mm-hmm. But under the Florida lemon law case, there are I think Justin's looking it up.
If it pulls up real quick.
If it pulls up real quick. I know under Magnuson-Moss, 3 repair attempts, you got a claim. Okay.
So lemon law period is 24 months. But how many you
got to give them? You have to give them an opportunity to repair.
Yeah.
I just don't know how many times you give them a chance. Does the state how many repair attempts?
No, 10 days to respond. 3 times.
3 times.
3 times too. Yeah, so, both are 3.
So you have to give them 3 attempts,
mm-hmm.
and it's within 4 months of purchasing the vehicle.
Yeah, or original delivery date.
Okay.
So I don't know if that means to the dealership. Because are you going after the dealership at that point, or are you going for the manufacturer? Yeah.
You're going after Chrysler.
The manufacturer.
Yeah.
Yeah.
Mm-hmm.
Are you? Has it been 24 months since you've had the car?
No, it's been about 5 weeks.
Okay.
Oh, that's
it's
right.
been about 5 weeks, and I'm on my 2nd issue.
Yeah.
So it sounds like if you have another one,
if you have another one, you got it. Yeah.
Then you're in the green.
So right now, if they fix those 2, and it's working, then you don't have don't have a claim. But if time goes by and you have, even though the 24 months is gone, and if a 3rd attempt is made, then you'd have a.
And what's interesting here for lemon law, it looks like if it's the same defect has been repaired 3 times. Yeah.
He said it's 2 different ones.
He said it's 2 different ones.
Right.
Mm-hmm.
So this is probably just, statistically low. I've never had anything really fail on vehicles like this. So to have 2 different things is probably kind of like winning a lottery.
I mean, do you feel comfortable that they've repaired the 2 mistakes or the 2 items at this point?
Yeah, I think it's going to be fine. I just was kind of educated. I did look at that the first time thinking, wow, 98 miles on a vehicle and I got to have it towed away.
You had 5 weeks. Yeah. I mean, it's not been. But
the first one was 4 days.
yeah. I know you had 5. Yeah, so I think, but even if the 2 years goes by, you still have Magnuson-Moss. The
Really?
2 years, the 24 months.
All right. Well, I'll keep that in mind. I hadn't heard that phrase before.
Yeah, that we could help you with. And we work on a contingency with that, so there'd be no upfront money.
And is that one the same repair 3 times, or
yes,
if it's 3
again,
different,
same repair
kind of deal?
3 times. And you know what we typically do? People will call us. Well, I've had it twice. We'll go ahead and send it in for the third one. And as long as you have the repair attempts, it's very simple. As long as you've had the repair, you can prove the repairs, and you have a warranty on it. Show you had a warranty, then you're entitled to money out of the law.
Yeah.
And typically, they don't buy under Magnuson-Moss. They don't really buy the car back. They'll just give you a lump sum of money. They'll say, okay, well, I mean, the car's not really running the way it should be. We accept, $15,000 or $10,000. Most people, and you can do that Magnuson-Moss. It applies not just to cars. It's boats, RVs, motorcycles, anything with a warranty. You can use that federal law for anything, any warranted item. So it doesn't have to be just cars.
So maybe for now, Mark, it's hold on to the receipts of the repairs.
Right.
Hopefully.
All right, well, that sounds good. And I mean, my common sense tells me it's probably going to be okay, but I was kind of looking into it ahead of time.
But you see,
What?
yeah, I know. You never know. I mean,
hold on to it.
For that quick to have something go
It's surprising.
wrong.
Yeah, well,
Right.
and definitely alarming.
I mean,
Yeah, I mean, it's certainly not the dealership's fault. It's just, one of the things that you start to wonder.
are there like serious problem where the car doesn't start or something? I mean, is it a...
No, the first one was like a power steering went out, but I haven't felt a car without power steering in a long time.
Man, I haven't...
that one can be bad if that one shuts off when you're steering,
Oh, wow.
unless
What
you
was
pay attention.
Was it like a leaking, a leak or something that didn't, the fluid?
Now they're electronic, so it's not
Like
fluid
fuse
anymore.
or something. Yeah.
No more fluid. It's all it's a computer thing.
Yeah.
Yeah.
It's
All
a
right.
computer glitch. Okay,
Well, guys, I think you answered my question. Probably I'm going to be okay, but I'll keep that in mind for.
Right.
It's not necessarily lemon law I want to consider.
yeah. And that applies to anything: boats, motorcycles, everything.
It's good to know.
Toasters.
All right. Thanks, Mark.
Yeah.
We appreciate it. Yeah, and feel free to call back if the problem persists. We're here to help.
Yes, sir.
And that'll probably do it here for Legal
I think
Live.
we got it.
Yeah, that was a good show.
Good show.
We will put the whole podcast up at WOKV.com if you missed any of it and want to catch up. And obviously, we will be back next week with more Legal Live, sponsored by Farah Farah, 104.5 WOKV, Jacksonville's News and Talk. Have a good weekend. We'll see you next week.